What is the applicable law? Contracts for the sale of goods are governed by the Uniform Commercial Code, UCC. Goods are all things movable or severed from land at the time of identification of the contract. Here, the subject matter of the contract is blank. Blank are movable objects. Thus, this contract will be governed by the UCC and supplemented by common law. Certain rules within the UCC apply only to merchants. Status of parties. Certain rules within the UCC apply only to merchants. The UCC states that a merchant is one who deals in goods of a kind, or otherwise by his occupation sets himself out as having special knowledge or skill peculiar to the practices or goods involved in the transaction. Here, A sells widgets to stores for retail sale, and B is a retail selling widgets to the public. Thus, they both deal with widgets in the regular course of business and will, therefore, be considered merchants. Was there contract formation? Contract formation requires mutual assent supported by sufficient consideration. Under the UCC, contracts may be formed in any manner sufficient to show agreement, including conduct by both parties which recognizes the existence of such a contract. The presence of mutual assent may be evidenced by a valid offer and a timely acceptance. Was there an offer? Catalogs. An offer is a manifestation of willingness to enter a bargain, so made as to justify another person in understanding that his assent to the bargain is invited and will conclude it. Was the catalog an offer? Here, A sent a catalog to B. Although catalogs indicate a merchant wants to sell their product, catalogs are generally not considered to be offers, because they are circulated to large numbers of potential buyers rather than specific offerees. And if considered offers, would bind the offeror to an unlimited number of acceptances. The catalog is best characterized as inviting others to make offers to buy the catalog items. Was B's purchase order an offer? Manifestation of intent to enter a bargain can be evidenced by definite and certain terms. Here, the purchase order specifies the catalog price, a quantity term of 100 cases, delivery in Stockton, and a description of the item to be sold, widgets. It is sent to a specific offeree. Given the fact that A, through its catalog, has solicited offers, it is reasonable for A to know their assent to the terms of the purchase order and is invited and will conclude the bargain. B has made a valid offer. Did A accept B's offer? An acceptance is a manifestation of assent to the offer by the offeree in the manner invited or required by the offer. If no specific manner is required, the acceptance may be in any manner reasonable under the circumstances. Here, A sends a confirmation accepting B's order. The confirmation mirrors all the terms of the offer except for the delivery term. At common law, the failure of an acceptance to mirror each and every term of the offer would be considered a rejection of the offer and not an acceptance. The UCC, however, will allow an acceptance or confirmation sent within a reasonable time to operate as an acceptance even though it states a different term from the offer, unless the acceptance is made expressly conditional on the offeror's assent to the different term. Here, the confirmation states that the acceptance is subject to, in quotes, the term on the reverse side of the confirmation. Courts have consistently held that the intent of the offeree not be bound unless the terms of the acceptance or terms of the bargain must be clearly and unequivocally stated. Courts have found that the subject to, in quotes, language does not satisfy 2-207's requirement that the acceptance be made expressly conditional, quotations, upon assent to the terms of the acceptance. Therefore, because A's confirmation indicates assent to the offer and does not make its acceptance expressly conditional on assent to the delivery term, A's confirmation is an acceptance. Is the bargain supported by sufficient consideration? Consideration is bargained for legal detriment. To be bargained for means that each promise or performance was sought by and was given in exchange for the other. Legal detriment is to forbear from doing what one is legally privileged to do or to do what one has no legal duty to do. Here, A bargains for money in exchange for its widgets. B bargains for widgets in exchange for the payment of money to A. Outside their agreement, A has no legal duty to supply B with widgets, nor does B have a legal duty to give A money. Therefore, bargain is supported by sufficient consideration. In conclusion, because there is mutual assent evidenced by a valid offer by B, an acceptance by A, and the presence of sufficient consideration, an enforceable contract has been formed between A and B. Done.